Welcome back to the Deep Dive. We're continuing our journey through the MPEP, the Manual of Patent Examining Procedure.
Yep, section by section.
Today, we're in Chapter 1200, Appeals, and zooming in on Section 1210. That's actions subsequent to examiner's answer, but before board's decision.
Right, a really specific window of time in the appeal process. And our goal today is basically to map out what happens procedurally during this phase. It's that period after the examiner gives their answer to your appeal brief, but before the PTAB, the Patent Trial and Appeal Board, makes its call.
Okay, so the examiner's responded, you're waiting for the board.
Uh-huh.
What now? It sounds like a quiet period, but MPP 1210 suggests there's actually a lot going on, or at least specific rules about what can go on.
Exactly, it's not just dead time. And the central theme, really the defining concept here, is jurisdiction. Who's actually in control of the application?
Right, who has the ball? Does it shift?
It absolutely shifts. That's maybe the biggest takeaway from 1210. Jurisdiction moves from the patent examiner who's been handling the case over to the PTT.
And is there a specific moment, like a clear trigger for that handoff?
Yes, definitely. The rule, 37 CFR 41.35a, spells it out, jurisdiction passes to the board at one of 2 points. Either when the applicant, you, files a reply brief,
Okay.
or when the time limit for filing that reply brief runs out. Whichever one of those happens first, that's the moment. Bing, jurisdiction transfers.
So filing that brief, or just letting the clock run out on filing it, that's the switch.
That's the switch, and it's a significant one. Once the board has jurisdiction, the examiner, well, they fundamentally step back. They don't have the authority to act on the application anymore. Unless the board specifically sends the case back to them, which is called a remand. We'll probably talk more about that later.
Okay, so the board's in charge now. What if, during this time, you discover something important, like maybe some really relevant prior art or new data that supports your invention? Can you just shoot an IDS, an information disclosure statement, or maybe an affidavit over to the board?
Generally, no. That's a key point in 1210. While the board has jurisdiction over the appeal itself, they typically won't consider new submissions that aren't directly related to the appeal arguments already presented. So things like IDSs, new affidavits, even petitions on unrelated matters.
They just get ignored.
Not exactly ignored, but they're not acted upon by the board. The MPP says they're usually held in abeyance. Think of it like they're put on pause, just sitting in the file.
Okay, so noted but not reviewed.
Right. They'll likely be dealt with later, perhaps if the case goes back to the examiner, but the board's focus during the appeal is on the record as it stood when they took jurisdiction.
Now, going back a step, just before the board fully takes over, sometimes the examiner's answer itself can contain a surprise, right? We've touched on this.
Yeah.
They might include a new ground of rejection in that answer.
Yes, exactly. And MP 1210 points back to the rules for handling that, primarily in 37 CFR 41.39b. If the examiner does raise a new ground in their answer, you as the applicant have choices. You don't just have to wait for the board.
A fork in the road situation. What are the options?
A definite fork. You have 2 months, and this timing is important from the date of that answer with the new ground. Option 1. You can file a reply under 37 CFR 1.111. That's basically asking to reopen prosecution. You're telling the examiner, hey, let's pause the appeal and deal with this new issue directly with you first.
Makes sense. Go back to the source. And option 2.
Option 2 is you file a reply brief under 37 CFR 41.41. This means you want the appeal to continue, and you want the board to consider this new ground along with everything else.
So either back to the examiner or keep it moving towards the board, but address the new point in your brief.
Correct. But here's a really critical catch that MP2 1200 warns about, and it applies here. If you choose option 2, the reply brief, to keep the appeal going, but you attach any kind of amendment or an affidavit or any other new evidence to that reply brief,
Uh-oh, sounds like trouble.
it automatically changes the nature of your filing. Even if you intended it as a reply brief for the appeal, the rules say it gets treated as a request to reopen prosecution before the examiner. Essentially, it forces you down path number 1, whether you meant to go there or not.
Wow. So if you want the board to rule on the new ground, that reply brief has to be just argument. No new evidence or amendments allowed with it.
Precisely. You have to be super careful. It's a common trap. And another thing about that 2-month window to respond to a new ground.
Yes.
It's generally not extendable under the standard fee-based extension rule, 37 CFR 1.136a. While many deadlines in patent prosecution can be extended by paying a fee, this specific one under 41.39b is rigid. You hit that deadline or you lose the chance to choose.
That is a hard deadline then. Good to know. And just quickly, what counts as a new ground? Is it just any change?
Not just any change. It generally means the examiner is changing the fundamental basis or reasoning for the rejection, like relying on new evidence or a completely different rationale than before. Cases like in recroning or in relievum give some guidance. It has to be more than just tweaking the old argument.
Okay. We know how the board gets jurisdiction. How does their control end? What are the ways a case leaves the board's docket?
MPP 1210 lists several ways this can happen. One we already touched on is a remand.
Sending it back downstairs to the examiner.
Exactly. The board can decide it needs more work done by the examiner, or maybe the director of the USPTO steps in and orders a remand before the board even issues a decision.
Okay, remand is one way out. What else?
Well, the most standard way is the board issues its final decision on the appeal. Once that decision is out, the board's active jurisdiction over the application itself usually ends, pending any further appeals to the courts.
Right. Can the applicant also end the board's jurisdiction? Take matters into their own hands.
Absolutely, and these are often strategic moves. One way is by filing an express abandonment under 37 CFR 1.138. Maybe you look at the examiner's answer, maybe you reassess your chances and decide, you know what, let's abandon this appeal and maybe file a continuation application instead, once that abandonment is properly filed and recognized.
The board's involvement stops.
Correct. Jurisdiction ends. Another very common way for the applicant to end the appeal is by filing a request for continued examination, an RCE under 37 CFR 1.114.
The RCE. That basically reopens prosecution, right?
Exactly. Filing an RCE is like hitting the brakes on the appeal. It pulls the application out of the board's hands and sends it right back to the examiner for more prosecution. Maybe you want to end claims, submit new evidence, things the board wouldn't look at during the appeal itself. It immediately terminates the board's jurisdiction. The sources also mention using a petition to withdraw from issue if the case was somehow allowed before the appeal concluded to clear the way for an RCE or abandonment.
So abandonment and RCE are two key tools for the applicant to redirect the case away from the board.
Definitely strategic options. And finally, jurisdiction can also end if the applicant fails to follow the rules, like missing a deadline or not responding properly, which could lead the board to just dismiss the appeal altogether.
With all these potential off-ramps abandonment, RCEs, it sounds like, letting the board know what you're planning is probably a good idea.
It's highly encouraged in MPEP 1210, yes. Appellants are asked to promptly inform the board's clerk if they decide they're going to abandon the application or refile it as a continuation or file an RCE.
Why the emphasis on promptly? Just good manners.
It's more about efficiency and avoiding problems. It stops the board from wasting its time and resources writing a decision for a case that's effectively dead or moving back to the examiner anyway.
Makes sense. Save everyone the effort.
Right. And there's a potential downside if you don't tell them promptly. The MPP warns that if you say, abandon the application but don't tell the board, and then they issue their decision, the board might later refuse your request to vacate that decision even though you already abandoned it. So timely notification can prevent that kind of procedural mess.
Let's circle back to remands for a second. You mentioned the director can order one, or the board itself. Why might the board remand a case administratively, like not based on the merits?
Good question. The sources suggest this often happens for procedural reasons. Maybe the file is a mess, it's incomplete, or there's some deficiency that prevents the board from doing a proper review. They might send it back to the examiner simply to get the file in proper order before they can proceed.
Sort of a clean up this file before we look at it situation.
Pretty much, yeah.
If a case is remanded, say, after the examiner already wrote their answer, what happens next? Does the examiner just issue a supplemental statement?
They might, or as mentioned in the MP 1200 context, the examiner could issue a completely substitute examiner's answer after the remand. This would be a new answer, potentially addressing the issues raised by the board or director that led to the remand.
And if that happens, does the applicant get another chance to respond, like the options we discussed for a new ground?
Exactly the same options, generally. If you get a substitute examiner's answer after remand, you're back at that familiar fork. File a reply under 1.111 to reopen prosecution with the examiner, or file a reply brief under 41.41 to keep the appeal going based on this new substitute answer. Another decision point.
Okay, wrapping this up, MPP Section 1210. Why is understanding this section so critical for patent practitioners or applicants involved in an appeal?
Well, because it really illuminates what's happening during that potentially long waiting period between the answer and the decision. It's not just a black box. It defines exactly when control shifts, what you can and cannot do while the board has control, and all the different ways that period of board control can end, whether it's the board's final word, a remand back, or a strategic choice you make, like abandoning or filing an RCE.
So it's about knowing the rules of the road for that specific leg of the journey.
Precisely. It highlights the importance of timing, knowing about those non-extendable deadlines, understanding the consequences of submitting certain documents at the wrong time, and recognizing the power of strategic moves like an RCE. Getting this phase right is crucial for keeping your application on track. And remember, time spent at the board isn't just waiting time, it can actually factor into patent term adjustment calculations later on, so these procedural steps have real downstream effects.
This has been really insightful. Section 1210 truly details the mechanics of that handoff between the examiner and the board. It makes it clear that jurisdiction isn't just some abstract legal idea. It's the practical reality dictating who's driving the bus at any given moment.
Yeah, knowing when that power shifts, what's permitted during the board's phase, and how to exit that phase, whether it's the board's decision or your own action, it's all fundamental to navigating an appeal effectively. It's about managing the process, even when it seems like you're just waiting.
So here's something to think about. Knowing these very specific triggers for when jurisdiction starts and ends, and the precise actions allowed or disallowed during that board phase. Does that change how you might plan your entire appeal strategy, even from the very beginning? Does it make you anticipate the post-answer possibilities much earlier?
It's interesting, isn't it? The MPP lays out these procedures with such detail, almost like a complex flowchart. It really emphasizes the need for careful planning at every stage.
Absolutely fascinating stuff. And before we sign off, a special thank you to Mike Shepard, our creative director who pulls this whole audio series together.
Yes, thanks, Mike. And for everyone listening, please keep this in mind.
Disclaimer. This summary of the MPEP was generated using AI tools, including ChatGPT and NotebookLM, and may contain errors or omissions. It is provided for general educational and informational purposes only and is not legal advice or a substitute for formal instruction. For authoritative guidance, consult the official MPEP, a qualified instructor, or a registered patent practitioner.